coming up with the order of witnesses is something that we usually don't do until very, very close to trial. Part of it is because of scheduling issues that you might have with experts or certain witnesses, so you have to put them in where you put them in. But you want to still make sure that the case can flow wherever that expert is going to pop up or wherever that witness is available. And so that's something usually we leave till probably the week before.
It just depends. If you have a lot of experts and you need to start. You can't wait till the week before because you've got scheduling issues, and our paralegals will just tell them all to show up the first day of trial, and that won't work. So that I think it really depends. But in most cases, you do have to wait a little later because you don't know for sure what the order is, how long people are going to take. You also don't know what day you're actually going to start, how long is this judge going to work each day, and your experts have to have some flexibility on that. And if they're not willing to, they just need to work for somebody else. But yeah, I think the order of witnesses is really important.
Yeah, it is important. There's a couple of things that you need to think about. There's certain witnesses that you can begin in one day and end in another day, and it will be fine. There's other witnesses that it will be totally confusing to the jury. They'll forget what was said. They'll lose track. You have a good sequence, and then the next day they come back and they've forgotten everything. And so you have to think about those things. How long is a witness going to take? Usually, when we have deposition video clips, I write down how long the clip is, so that if I need 15 minutes to stall till another witness arrives, I know which clips we can play. Right? So that or I know what witness I can call. Well, it's, the person, my plaintiff's brother, and he was going to tell these 3 stories, so it'll take 20 minutes. Why don't I just call him in the meantime while I'm waiting for so-and-so to arrive? So having an idea about kind of where you can move things around if you need to in an emergency, because things pop up in trial, and you can't assume you're going to be able to do it the way that you want.
But I think it's important to start strong. Start with a witness. It's going to tell as much of your story as possible, but also you want to start with a witness that's not very impeachable, that's going to testify well, that they're not going to have a great cross on that witness. If possible, I'd like to start by proving the defendant did something wrong before I start talking about harms and losses. Now, ideally, I would have let's say you have a catastrophic crash. You can have the police officer talk about what they saw, why it's the defendant's fault, and about the harms and losses after that, and all in one witness. That would be ideal. A lot of the cases I've tried, the harms and losses aren't obvious that day at the scene. They start hurting later, and it develops over time. So that doesn't always work. But I think it's important, though, to start strong. Sometimes I start with the defendant because you could do a cross with them and prove what you need. Sometimes, though, you have to start with an expert to set what are the rules, what are the standards, and to prove up the learned treatises and other publications you need to effectively cross a defendant. It just depends, but I think it's important to think about that. The other thing is think about what's the jury's energy throughout the day. So, at the beginning of the trial, that's when they're going to be the most attentive. Later in the afternoon, that post-lunch crash. So let's say you have defendants all the time call they do video depositions of their medical experts. Well, you're planning out your trial, maybe the second or third day of trial. You can, you had some good points you made during theirs too. So you'll present their person by video, maybe 2 in the afternoon when everyone's fallen asleep, and then your 30 minutes of good stuff's going to go first, and then they're going to have their hour of video running on after that.
Yeah.
That might not be a bad idea. Just thinking of the jury's energy and who's going to hear what and when, and. But definitely, and other people, Andy Young disagrees with me. He's been on this podcast, and he thinks you should start with a witness about what great people these were and stuff. But I respectfully disagree with Andy. I think in most cases, we're going to look like we're trying to get their sympathy, and we're going to arouse suspicion from the jury if we don't go prove that they are blameworthy before we start talking about what went wrong.
Yeah. And I think then on that note, you start strong, but you also have to end strong. What you don't want to do is sit down on your weakest witness.
Absolutely.
And so we usually are very careful about who we select to go last. And it's, frankly, usually not the plaintiff. It's usually someone to talk about the harm that's been caused, right? It's the end of your story. This is what harm is caused. This is what I'm hoping that my friend, my family member, my coworker can get back to in the future. And you leave on a note of hope, but you also get some testimony about that this is their life now.
And that's something I've learned over time, because I used to always call the plaintiff last, and my logic was start with what the defendant did wrong, then get all the lay witnesses to bolster that my person's really hurt before I put them on, so they'll be more believable. But then I would always end with all the cross-examination on every little inconsistency in the medical record, every little thing you said different than your depo. So, I like now to sandwich the plaintiff in there and just have some people showing the plaintiff's really hurt, then the plaintiff, and then ending with their best witness or two about how they are really hurt to diffuse any of that cross.